This is the only footage that exists of this man answering questions under oath. His company fought for 3 years to keep it sealed. His name is Richard Sackler. In 1996, his family's company launched a painkiller called OxyContin. At the launch celebration, according to a complaint later filed by the Massachusetts Attorney General, Richard Sackler stood up and told the room what was coming. The launch, he said, would be followed by a blizzard of prescriptions that will bury the competition. The blizzard would be so deep, dense, and white. He was right. Since 1996, OxyContin has sold more than $35 billion worth of pills. Here's the part almost nobody has straight. The company that sold those pills pleaded guilty to federal crimes. Not once, twice, 2 guilty pleas, 19 years apart. Felony charges both times. And in between those 2 guilty pleas, a forensic audit found that the family that owned the company took $10.7 billion out of it. Not one member of that family has ever been criminally charged. Today, the company no longer exists. As of May 1st, 2026, it has been dissolved. The corporation took the conviction, the corporation took the fine, the corporation took the dissolution, and the money had already left the building. There is a specific year the money started moving. And what happened in the 12 months before it is the whole story. For 50 years, if you knew the name Sackler at all, you knew it from a wall. The Metropolitan Museum of Art, the Smithsonian, the Louvre, the Guggenheim, Oxford, Harvard, the Tate. Their name was carved into the entrance of some of the most important cultural institutions on Earth. It was the name of a family that gave things away. The fortune began with 3 brothers, all of them doctors, Arthur, Mortimer, and Raymond Sackler. In 1952, they bought a small patent medicine company in New York called Purdue Frederick. It sold laxatives and earwax remover. The oldest brother, Arthur, did something that mattered more than the company. He reinvented how drugs are sold to doctors. Medical journal advertising, sales representatives in physicians' offices, studies funded by the manufacturer, quoted by the salesman. Arthur Sackler built that playbook. He was inducted into the Medical Advertising Hall of Fame. Arthur died in 1987, 9 years before OxyContin existed, and his side of the family has always insisted they had nothing to do with it. The company's first serious painkiller was called MS-Contin, time-release morphine, mostly for cancer patients. It worked, and it made money, and its patent was running out. Raymond's son, Richard Sackler, trained as a physician and joined the family business. By the mid-90s, he was running research and development. In December 1995, the FDA approved a new drug from Purdue, OxyContin, in the same time-release shell. And the label carried a sentence that would end up at the center of everything. It said the time-release design was believed to reduce the abuse liability of the drug. Believed, not demonstrated, not proven in a trial. Believed. Purdue took that sentence and built a sales force around it. This was the era when American medicine was told it was under-treating pain, that pain should be measured like a pulse, a 5th vital sign. Purdue's representatives arrived into that moment with bonuses, branded merchandise, and a drug they said was harder to misuse. In 1996, OxyContin did $48 million. By 2000, it was over $1 billion a year. And in small towns in Appalachia and Maine and the Rust Belt, doctors and coroners started noticing something at the same time. The blizzard had arrived. It just wasn't burying the competition. The earliest crack in this story is dated May 1997. OxyContin had been on the market for about a year. Purdue's head of sales and marketing, Michael Friedman, wrote to Richard Sackler about a problem. Doctors had a mistaken belief about the drug, and the mistake was helping sales. Many physicians believed OxyContin, the active ingredient in OxyContin, was weaker than morphine. It is not. It is roughly twice as potent, Friedman wrote, and this was reported by Stat News and ProPublica out of the sealed deposition record. It would be extremely dangerous at this early stage in the life of the product to make physicians think the drug is stronger or equal to morphine. We are well aware of the view held by many physicians that OxyContin is weaker than morphine. I do not plan to do anything about that, Richard Sackler's reply, according to that same record, was 4 words. I agree with you. Nobody lied in that exchange. That is what makes it the most important document in this story. A misunderstanding was identified at the top of the company, and a decision was made to leave it exactly where it was. The second crack appears in February 2001, in another email. By then, the reports of misuse were public. Richard Sackler wrote to a colleague about who should be blamed. His words were later disclosed in litigation and reported by Stat News and ProPublica. We have to hammer on the abusers in every way possible, he wrote. They are the culprits and the problem. They are reckless criminals. Hold that sentence. It is a strategy, and the company would run it for the next 20 years. The drug is fine. The people taking it are the problem. Federal prosecutors in the Western District of Virginia did not agree. They opened an investigation and ran it for 4 years. On May 10, 2007, it ended in a guilty plea. The Purdue Frederick Company pleaded guilty to a felony, misbranding OxyContin with intent to defraud and mislead. The total came to $634,515,475. 3 executives pleaded guilty personally: the president, the chief legal officer, and the former head of medical affairs. Misdemeanors. No prison. The government's own case established that the company had falsely claimed the drug was less addictive and less prone to misuse than other painkillers without the research to support it. No member of the Sackler family was charged. Not then. Not in the 20 years since. At the time, this looked like the end of the story. $600 million, a felony on the record, 3 executives with convictions. It wasn't. Sales kept climbing after the plea. So did the deaths. And starting the following year, something changed inside the company that has nothing to do with medicine. The money started leaving. In 2019, in bankruptcy court, Purdue was forced to commission a forensic audit of its own cash. The accounting firm AlixPartners produced a report roughly 350 pages long, tracing where the company's money went. NPR reported the findings in December 2019. Here is the number that matters. Between 1995 and 2007, the first 12 years of OxyContin, the boom years, the family took roughly $1.3 billion out of Purdue. Between 2008 and 2017, the 10 years after the guilty plea, they took $10.7 billion. Read those 2 numbers in order. The withdrawals multiplied roughly 8-fold in the years immediately following the company's first federal conviction. Where did it go? According to the audit and the reporting on it, into family trusts, into holding companies, and into accounts in jurisdictions including the British Virgin Islands and Luxembourg. Offshore, layered, legally. The family's response has been consistent, and it belongs in this video. They have said roughly half of that money went to taxes and to reinvestment in other businesses, and that every distribution was lawful and properly approved. And that is the part people miss when they get angry at this story. Almost none of this required breaking a rule. Purdue Pharma was structured as a limited partnership, privately held, ultimately controlled by family trusts. The family sat on the board. The board approved the distributions. So the same people who owned the company voted on how much of the company's cash to send to themselves. That is not a secret. It is how a private company works. Now put that structure next to the criminal case. When the Justice Department charges a drug manufacturer, the defendant is the manufacturer. A company cannot be handcuffed. It cannot be sentenced to prison. It can only be fined, monitored, and eventually shut down. And a fine only lands if the money is still inside when the verdict arrives. Here is the loop from the opening of this video, and here is where it pays. The blizzard was a sales plan. The withdrawal schedule was something else. The Massachusetts Attorney General's complaint, filed in 2019, alleged that family members were directly involved in the decisions to push sales harder after 2007. The Sacklers called that complaint false and misleading and moved to dismiss it. And in that sealed deposition, the one from the start of this video, Richard Sackler was asked about all of it for more than 8 hours in August 2015. Purdue fought the release of that video all the way to the Kentucky Supreme Court. Stat News won a court decision ordering it out. ProPublica eventually published the full recording. Watch it and you will not find a confession. You will find a very careful man answering narrowly. The family's position throughout has been that they acted ethically and lawfully, and that they were not responsible for what the drug did. They said so under oath, on camera, in front of Congress. That hearing is Act 5. First, the number this video has been avoiding. Since 1999, opioid overdoses have killed close to 500,000 people in the United States. That figure covers prescription opioids, heroin, and later fentanyl. And no honest account puts all of it on one company. Purdue has always argued its market share was small and shrinking. Stat News examined that argument in 2019 and reported that the data Purdue used to minimize its role was selective. There is one more turn, and it is the one people get wrong most often. In 2010, Purdue reformulated OxyContin to make it hard to crush or dissolve. That worked. Multiple studies found misuse of the pill itself dropped quickly after the change. It was a genuine safety improvement, and Purdue points to it to this day. Then, in 2015, researchers Theodore Cicero and Matthew Ellis published a study in JAMA Psychiatry, surveying more than 10,000 patients in treatment. Of the people who had been misusing OxyContin, about a third said they responded to the reformulation by switching to another drug. Roughly 70% of that group said the drug they switched to was heroin. That is the bridge into the second half of this crisis, the one that ends in fentanyl. The pill got safer. The people did not stop. What is not in dispute is where it landed. This did not fall evenly across America. It concentrated in places with hard physical work, thin medical infrastructure, and towns where one pharmacy served 3 counties. A generation of parents in those towns lost children. A generation of children lost parents. Foster care roles climbed. Grandparents became guardians. Emergency departments rebuilt their protocols around a single class of drug. And the people at the center of it were, overwhelmingly, patients who had been handed a prescription by a doctor who trusted the label that said the design was believed to reduce the abuse liability of the drug. 25 years later, in a federal courtroom in New Jersey, some of those families finally got to speak. Getting there took the largest bankruptcy fight of the decade. September 2019. Facing more than 2,000 lawsuits, Purdue Pharma filed for Chapter 11 bankruptcy protection in White Plains, New York. Bankruptcy does something specific. It freezes every lawsuit against the debtor and moves them all into one court. Purdue filed. The Sackler family did not. The family was never bankrupt. Reporting placed their wealth at around $11 billion. That figure comes from documents released by the House Oversight Committee in April 2021. In September 2021, Judge Robert Drain approved a plan. The family would pay about $4.5 billion. In exchange, they would receive legal releases, a permanent shield against opioid lawsuits, third-party releases, the mechanism that lets people who never filed for bankruptcy get the protection of someone else's. Victims' families stood outside that courthouse and said the quiet part out loud. The company went bankrupt. The owners went to their houses. In December 2021, U.S. District Judge Colleen McMahon overturned it. She ruled the bankruptcy court had no authority to grant those releases. In 2023, the Second Circuit reinstated the deal. And then it went to the Supreme Court, June 27, 2024. Harrington v. Purdue Pharma. The court ruled 5-4 that the bankruptcy code does not authorize releases for third parties who have not consented. Justice Gorsuch wrote the majority. Justice Kavanaugh wrote the dissent, and his objection was practical. Strike the deal, and billions of dollars for victims and for treatment programs disappears with it. Both sides of that ruling were right about something, which is why it took 19 more months to fix. In January 2025, a new deal was announced. $7.4 billion. The critical change, the releases became opt-in. Anyone who wants to keep suing the Sackler family individually can. Anyone who takes the money gives that right up. Consent instead of a court order. And the deal, like every deal before it, contains no admission of wrongdoing. The bankruptcy court confirmed it. It took effect on May 1st, 2026, 14 weeks ago. And 3 days before it did, the company was finally sentenced. Purdue Pharma pleaded guilty in November 2020 to 3 federal felonies. 1 count of conspiracy to defraud the United States and violate the Food, Drug, and Cosmetic Act. 2 counts of conspiracy to violate the federal anti-kickback statute. In plain terms, failing to maintain a program to stop its pills from reaching the black market and paying doctors through a speaker program and through an electronic records company, in a way prosecutors said was designed to increase prescriptions. The headline number was $8.3 billion, a $3.544 billion criminal fine, $2 billion in forfeiture. But Purdue was inside a bankruptcy, and there was never $8.3 billion sitting there to collect. Separately, in that same 2020 resolution, members of the Sackler family agreed to pay $225 million to settle civil claims under the False Claims Act. No admission of wrongdoing. No criminal charges. Sentencing was set for April 21, 2026, before U.S. District Judge Madeline Cox R. Leo. She postponed it by a week. The reason is in the court record, so that opioid victims and their families could be there in person. Per reporting from the Associated Press and PBS, Purdue forfeits $225 million to the Justice Department. Consider what was standing at the defense table. Not a person. A corporate entity that had already agreed to stop existing. One of the people who spoke was Stacy Schwab. Her words were reported from that hearing. My family just doesn't have the money to pay for private treatment for her, while they're sitting on billions of dollars. Purdue Pharma is gone. In its place is a new company called Noah Pharma, run for public benefit, with a board appointed by the states. The name that carried 2 felony convictions has been retired. The assets kept working. So let's finish where every one of these stories has to finish. Follow the money out. On the effective date, the Sackler family paid more than $1.5 billion. Then roughly $500 million in May 2027, $500 million in 2028, $400 million in 2029. The full contribution runs out over about 15 years, not a check. A payment plan. For individuals harmed, the plan sets aside up to $865 million for adults and for children born dependent. Individual payments were structured to range from about $3,500 to about $48,000. In April 2026, ProPublica and the Philadelphia Inquirer reported what that looks like in practice. Payments for a family member's fatal overdose have come in as low as $8,000. Many claimants were disqualified on documentation, pharmacy records from 15 or 20 years ago that no longer exist. Their reporting found that as of June 2026, individual claimants still had not been paid. $10.7 billion out, over 10 years on schedule and on time, $8,000 in for a dead child, if you can find the paperwork. The museums took the name down. The Met in 2021, the Louvre, the Tate, the Guggenheim, the Serpentine. That is what accountability looked like here. A wall got repainted. At that December 2020 congressional hearing, Cathay Sackler was asked whether she would apologize for her personal role. Her answer is on the record, in full. I have tried to figure out, is there anything that I could have done differently knowing what I knew then, not what I know now? And I have to say I can't. There is nothing that I can find that I would have done differently based on what I believed and understood then. Richard Sackler at the same hearing denied that he, his family, or the company bore responsibility for the crisis. That was reported at the time by CBS News and others. It remains their position today. And they are entitled to it because the record supports the narrow claim they keep making. No Sackler has been convicted of anything. No Sackler has been charged with anything. That is the myth this video came to take apart. Not the myth that they were guilty. The myth that the system missed something. It didn't miss anything. The company was the defendant because the company was always going to be the defendant. It pleaded guilty twice, paid what was left, and was dissolved. The owners were never in the dock because owning is not a crime, and a distribution approved by a board is not a theft. That is not a loophole somebody found. That is the architecture. It is available to anyone who owns rather than operates, and it is being used right now in industries that have nothing to do with medicine. $11 billion, a dissolved company, 500,000 dead, and a family that never saw the inside of a courtroom as a defendant. The blizzard buried the competition. It buried a great deal more than that. If you want to know how the next one of these gets built while everyone is still arguing about the last one, subscribe. We do one of these every week. Tell me in the comments, should a bankruptcy ever be able to protect someone who never filed for one?